Before Morton.
Thank you, Deputy Speaker. The Attorney-General, Australia's first law officer, has decided in his wisdom that organisations whose purpose include protection or conservation or research into the environment should not be allowed to take any legal action if they notice the government failing to do its job. Senator Brandis wants to amend a law that allowed an environmental group, the Mackay Conservation Group, to bring a successful application before the Federal Court in Sydney to have set aside the decision of the Environment Minister to allow the development of a coal mine in central Queensland. The legal application by the group has been described by the Prime Minister as sabotage, and Senator Brandis has been reported as saying he was appalled by the decision. I'll come to that word decision in a minute. What seems to have slipped the grasp of the government is that their minister did not properly make the decision, the job that he is paid to do. He didn't properly consider the two threatened species, the yakka skink and the ornamental snake, that would be affected by the proposed coal mine. It was imperative that he considered that fact before he made the decision, as per the law that John Howard introduced. The comments from the Prime Minister and the Attorney-General are even more bizarre, given that the minister's decision was not set aside by the decision of the federal court judge in this case. This was a consent order. It was a consent order by the respondents, in this case the Commonwealth of Australia, the Commonwealth Minister for the Environment and the Adani Mining Proprietary Limited, decided themselves that proper ministerial processes had not occurred and that the decision should be set aside. So it was not a decision, it was a consent order. This is simply the result of an incompetent government. The Attorney-General saw this horrendous miscarriage of justice as a horrendous miscarriage of justice, so now wishes to amend the Environment Protection and Biodiversity Conservation Act so that similar organisations to the Mackay Conservation Group cannot again keep the government to account and ensure that they make decisions properly as they are required by the law, John Howard's law. They propose to amend the EPBC's extended standing provisions, which currently allows environmental organisations to bring these challenges. Thinking this through logically, if that conservation group did not have the standing to bring the action, who would? Would it be the ornamental snake? Would it be the yakka skink? Now, I've been studying law or a lawyer for nearly over 20 years. I've seen a few snakes around the place, but I've never actually seen a legally qualified lawyer or skink. The mischief that the application was brought to correct was that a threatened species may become extinct by the development, and the minister had not properly considered that. Certainly, the yakka skink and the ornamental snake would not have standing and, as I said, nor any legal training. That's the very reason that the Howard government brought in the extended standing provisions. Those conservation groups are the only groups who would have standing to protect these endangered species. This is simply another scaremongering campaign by a desperate, disorganised government. Since July 2000, there have been 5,500 projects that have gone through the same approval process that the Adani coal mining project went through. Out of those 5,500 projects, how many were successful? 6! 6 out of 5,500. It's a complete overstatement by the Attorney-General when he said, and I quote, "The provision allows radical green activists to engage in vigilante litigation to stop important economic prospects." 6 out of 5,500. Do the maths. It's an outrageous statement, completely without merit. In 15 years, there have only been 6 successful challenges to these projects. And the most recent challenge could have been avoided altogether if Minister Hunt, the so-called Environment Minister, was doing his job properly. This is not about Australian jobs. This is about the jobs of the Prime Minister, the Attorney-General and the Environment Minister. This is political opportunism and wedge politics seen at the extreme. For the Prime Minister of the land, the guy that's actually supposed to provide us with a bit of vision, for the Attorney-General, the nation's first law officer and the Environment Minister, because that is his title, the Environment Minister, to engage in such behaviour. They must be lower than the belly of a Denisonia maculata, obviously, to not think of what this piece of legislation was introduced for. John Howard, not exactly a radical, or to quote the Attorney-General, not exactly a radical green activist, John Howard brought in this safeguard. So this is all about creating a fear campaign and a straw man to target because the the government has run out of ideas. We've seen it with their legislative agenda this week and last week here in Parliament. If we look at the cabinet agenda, a blank piece of paper, this is a government that has run out of ideas and is now trying to create fear and division in the Australian community, and they should be condemned for it.
I thank the member for Moreton. The question is that the Federation Chamber do now adjourn.